Gambo otya kasubire oli bulungi nze Dr. Muganzi nkwaniriza ku YouTube channel yaffe ngenda kusaba subscribinga baako omuntu omulala gwogabana naye eno channel. Njagala tuyite mu judgment ya Supreme Court. Munnange Mwami Museveni amaze ebbanga ddene nnyo ng'akozesa Supreme Court nga political tool okulwanisa abo abamulwanisa. Dr. Kano Kizabya sije mirundi mingi abadde mu court martial. President Bobi Wine mujjukira ebyaliwo mu mwaliwa yaleetebwa mu court martial. Ye kwegamba buli abamulwanisa abasejjusa bonna baaleetebwa mu court martial. Buli Munnayuganda avaayo n'amulwanisa akozesa court martial eno okubasiba n'okubatiisatiisa. But Supreme Court yavuddeyo neewa ensala yaayo mu musango gwa Kabaziguruka versus the Attorney General whether the trial of civilians in the court martial is legal or illegal. Kyatuyambye nti precedent yabadde set. Tumaze ebbanga munnange nga tusaba ensala eneweebwe nga tugamba nga twekalakaasa nga tubagamba bannayuganda ba civilians tebalina kutrayingibwa mu court martial. Kyatuyambye nti mu kunnyonnyola oba mu judgment eno actually abalamuzi batutegeezezza nti court martial si court kakiiko kakwatisa mpisa. You can call it a tribunal or a disciplinary committee. Nga parliament werina disciplinary committee nti disciplinary committee noza MP asezo jigenda miyezake nti wobaako nekyokola nga kiri against the rules and regulations of the parliament bakuweerezeeyo. Neeno court martial bwerina okubeera terina kubeerawo kutrayinga bannayuganda no. Erina kubeerawo kukwatisa mpisa mu bannamagye. Okitegeera. Naye abalamuzi bavuddeyo ne bawa grounds. Ogenda kunzikiriza nkuyitire mu grounds. Ndowooza ngenda kuwaako musanvu zokka zokka. Abalamuzi ze bavuddeyo ne bawa mujja kunsonyiwamu. Abalamuzi ze bavuddeyo ne bawa okusinziira ku ki? Okusinziira ku keso eyali yawaabibwa Kabaziguruka. Kabaziguruka yawaaba ng'agamba Kabaziguruka yatrayingibwa mu kooti y'amagye. We yatrayingibwa mu kooti y'amagye nga baagala kumusingisa musango. N'avaayo n'akola appeal. Actually kooti yavaayo n'egamba nti kikyamu okutrayinga aba civilians mu court martial. Kyaddako kyali ki? Anthony Deno naddayo n'agamba nedda kooti kyemwasaze si kituufu njagala muddemu mutunule mu guno omusango. So omusango gwo gubadde gye guli okumala ebbanga era bannayuganda bangi babadde basigala batrayingibwa mu court martial. Bino bye bigambo bya Kabaziguruka.
Ensalawo si yange ng'omuntu kinoomu wabula ya bannayuganda ffenna. Emabegako mu mwaka gw'2016 mujja kujjukira nti nakwatibwa n'envunaanibwa mu kooti ey'ekinamagye GCM General Court Martial nga nvunaanwa omusango gw'okulya mu nsi olukwe. Emisango gye nawakanya nga nkimanyi bulungi nti nze sibeerangako munnamagye. Sisabanga nako waliwo kuba nti nali nsabyeko ne bagaana naye sisabanga nako kwegatta ku magye. N'olwekyo tewali ensonga yonna lwaki baali banvunaana mu kooti y'amagye. Nagaana okukkiriza okuwoza mu kooti yaabwe era n'ensaba balooya bange tufayiringe constitutional petition tetwafayiringa era ne tuwangula. Gavumenti ng'eyita mu ssaabawaabi waayo yawakanya ensalawo ya Constitutional Court n'ejulira mu kooti ensukulumu mu ggwanga lino Supreme Court. Era olwaleero ni musanyufu nti kooti eno esaze omusango guno mu mazima n'obwenkanya nga yeesigamye ku tteeka constitution ey'eggwanga lino era esaziza amazima n'obwenkanya nti olwaleero kooti Mwami Museveni gy'abadde akozesa okunyigiriza naddala abo ab'oludda oluvuganya ng'abavubuka ba NUP abamazeeyo emyaka kati kumpi 4. Dr. Besigye nga sigwe mulundo okusoose guno ndowooza gwakubira era ng'ali mu court martial olwaleero Supreme Court egisatuludde egijjeewo era mu mateeka ga Uganda tetulina GCM nga kooti mu ggwanga lino wadde mulimubaddemu akakawayiro ndowooza balawuya bakanyonyole bulungi kaga nti is a subordinate court naye era nako it has to be reconstituted balina kugiza ojja teriiwo mu mateeka era nkubiriza bekikwatako mu bunnambiro abantu bonna abakyali mu kooti abakyali mu makomera ag'enjawulo bateebwe bunnambiro si kyakukolebwa nkya oba ku bbalaza wabula balina kukikola ssaawa eno nga kooti bweragidde.
That has been Kabaziguruka oyo musajja yali MP wa Nakawaye yatwalayo omusango. Then also bino bye bigambo leader of opposition bye yayogera after the judgment.
Nti kooti z'amagye zikozesebwa okufulugunya bannansi abatawagira gavumenti eno. Tulina political prisoners baffe nga NUP ababadde emyaka era n'okweyongerayo. Kakati juzi ne bongerako ne Dr. Kiza Besigye, Haji Obed Lutale, Council Aaron Kiza. Kubanga tebawagira gavumenti eno kyokudolabanga bakozesa kooti eno okufulugunya bannansi bakuteekayo eyo tokkirizibwa na kufuna kakalu ka kooti. Bwogezaako okwogera ku nsonga ez'enjawulo contempt of court ne bakusiba emyezi 9 n'ebirala bwe bityo. So kirungi nti kooti eno ensukkulumu ewuliriza amaloboozi g'abannayuganda g'abannansi abazze bagamba nti kino kikyamu okufulugunya bannayuganda nga mukozesa kooti y'amagye kubanga bannansi tewali nsonga lwaki babeera mu kooti y'amagye. Kino tuzze tutwogerako ebbanga eriwera. Kirungi nti amaloboozi ago bagawuliriza. Obuzibu obuli ku general court martial nga bwebadde bebeemulugunya ne bakutwalayo mu kooti yaabwe be bakuwozesa prosecution ate nga ab'amagye be batudde wali be balina okusala omusango guno kugamba nga tewali bwenkanya oli mu nsonga eno. Kirungi nti ensonga eno egenda kutereezebwa. Ate ekirala kooti kyekoze nti teyambye just bannansi ensonga eno okutereera n'ab'amagye nabo kubanga ab'amagye nabo babadde batulugunyizibwa nti oli w'amagye oli private onyiziza mukamawo meja oba captain oba ki n'akutwalayo just okubanga omunyiziza ne bakusalira ebisango ebitategeerekeka oluusi okutwala kalabba. Kati n'ab'amagye nabo bafunye obuwolero ensonga eno. Katusuubire nti ekiragiro kya kooti kino kigenda kuteekebwa mu nkola nnambiro kubanga ebiragiro bingi ebya kooti ebizze binyoomebwa. Kooti nega nti omuntu tumutadde kakalu ka kooti ne baddamu ne bamusiba nga tannafuluma na geeti ya kooti n'ebirala bwe bityo. Katusuubire nti ekiragiro kino kigenda kuweebwa ekitiibwa ekiteekebwa mu nkola.
Yeah, that was our leader of opposition, Bino, your Secretary General of Affairs.
A big day for democracy, for the rule of law, and for constitutionalism in this country. And as Honorable Sagona said, I think it is evidence that if you continue struggling, there are some small wins. We live under military dictatorship, but there are small wins here and there. And like we always say, the struggle can be everywhere. Our parliamentary teams will do their work there. People, lawyers will go to courts. Others will go on the streets. Every bit contributes to the struggle for better governance, for democracy, our pursuit for a better country. So for us as NDP, we are very, very delighted today because, as you know, the military court has been used to persecute, not to prosecute, but to persecute over 2,000 of our supporters since 2020. Over 2,000 of NUP supporters have gone through that court. Because that is, I shouldn't even be calling it a court because the Supreme Court has clearly said it is even not a tribunal. It is something just there. So we are very glad and we salute our comrades who refused to plead guilty. Those 9 people who refused to plead guilty. We have Bobby Am, who is still in detention, and many others who are still facing charges. Our comrade Achileo is still facing charges before that military court and others. So we are very glad with this ruling. We hope, like my brother Lop said here, that General Museveni will now not devise means of trying to defeat this court ruling. But also this is a win for the people of Karamoja. Every time you go to Chitara, you find hundreds of people from Karamoja who are taken to those military courts without any trial, and then taken to Chitara. They spend there years and years without trial, without even going back to court.
So that has been it. I want to read for you, I want to read for you what the court concluded on. I'm going to give you 7 grounds. The military court-martial is a competent court of law jury established by the law. The functioning of the court-martial as presently constituted is unconstitutional. It is not independent. Members are not required to be trained in law vis-a-vis judges in civilian courts. Eyokubiri egamba nti entekewa ya engeri court-martial gye yateekebwawo eri unconstitutional, tegoberera mateeka, teri independent. Okutegeeza nti teri independent, abo abalamuzi bonna boolaba munnange abatula ku court-martial, tereezemu wano kati ne computer yange sibanga njogera nga temundaba. Abo bonna boolaba abatula ku court-martial, munnange Mwami Museveni yabalonda. Ate tafaayo kulowooza nti ono yasoma amateeka, ono yasoma kino. Bwe kyonna kasowa oli mwana amagye bagenda kukuza lwanka, genda osala amateeka. So ngate bano abantu abalamuzi Museveni balonda bagenda wazesa abantu ye ate bennyini bakutte. Oli taata mu maka gwataddewo kooti ate gwawaapi omusango. Bajjajja olowooza bagenda kukola ki? Ekyokusatu, Supreme Court negamba the provision in the UPDF Act providing for the blanket trial of civilians of court-martial are unconstitutional. Nti akakawaiwai akali mu UPDF Act akakiriza court-martial okutryinga aba civilians, it is unconstitutional. Ekyokuna, the trial of military officers by the military court-martial for purely civilian offences as opposed to service offences specifically listed in the UPDF Act is unconstitutional. Munnange court-martial babadde bagikozesa ne bannamagye bennyini nga bagikozesa oba trying ku misango gye batalina trying bwa mu court-martial. Bamubanja renti bamutadde mu court-martial. Yalwanye nga tali wadde na ku mulimu bintu bya waka bamutadde mu court-martial. Yayombye n'omukazi bamutadde mu court-martial. Alina omukazi y'omu gwakwana n'omunamagye omulala bamutadde mu court-martial. Emisango egitali mu UPDF Act, emisango gye balina tryingibwa mu court-martial wegiri, bamubanja ssente omukutu omutadde mu court-martial. These are purely civilian cases, zirina kubeera mu courts with jurisdiction. Ne weesanga nga court-martial babadde bagikozesa okunyigiriza ne bannamagye bennyini. Point endala Supreme Court gye yavuddeyo negamba the hearing by military court-martial of offences in respect to which the jurisdiction to try them is restricted to civilian high court is unconstitutional. Nti court-martial okuwuliriza emisango, jurisdiction is okubeera nga kooti eyo yerina okuwulira emisango egyo. Buli kooti ebeera n'emisango gyerina okuwuliriza. Okitegeera, waliwo emisango nga high court yokka egiwuliriza, waliwo emisango nga lower court ziwuliriza, waliwo emisango ng'ogenda mu constitutional court nga courts endala tezigenda ziwuliriza. So buli court ebeera ne jurisdiction, oba jurisdiction ziyinza kubanga boundaries, nti gwe emisango gyo gigwa mu boundaries zino. So weesanga nti court-martial ebadde ewuliriza n'emisango gyetalinaako jurisdiction, ng'ewuliriza emisango gy'ebyobufuzi, purely political cases, ng'ewuliriza emisango egiri constitution. Niweebuuza tuli ku kiwano. So Supreme Court yavuddeyo n'ebijjawo. Nevayo negamba all ongoing charges and trials by the court-martials involving civilians must stop immediately. Court-martial eno ye yalimu Olivia Lutaya, ye yalimu baganda baffe bamachete, ye yalimu ono Charles Sanya yekubye emizimu, ye yalimu Dr. Kano Kiza Besije. Okitegera, so court-martial yavuddeyo negamba nti emisango egyo gyonna egirimu ba civilians girina ku stoppingibwa immediately, gitransferingibwe gigibwe mu court-martial, gitebwe mu court with jurisdiction, gitebwe mu court gye zirina okukozesebwa. ekyasembyeyo negamba this decision also applies to person previously convicted by court martial whose appeals are ongoing. Kati nga munamateeka muganda waffe Aaron Kiza pamusiba mu kkooti etalina na kumusiba ne bamusingisa omusango ne bamukwata ne bamusuula eruzira naye namala na appealinga nti kati abantu ngaabo nabo baye emisango gyabwe gina okukyusibwa ne bagiteebwa mu court with jurisdiction. Now Museveni yavuddeyo n'agamba nti eggwanga lino terifuga bannamagye. We didn't expect him to respect the decision of the Supreme Court. Supreme Court ye kooti esemberayo ddala nti kyesazeewo tekiwakanyizibwa nti ne Parliament eswatuula n'ekikubaganyako birowoozo. Naye Museveni alaba nti one of the tools mubadde mu ngalo emuggiddwako gy'abadde akozesa okututiisatiisa abadde agikozesa okukwata abantu abaana ba NUP bonna n'abateeka mu komera ateeke mu court martial. Okitegeera ninga terina jurisdiction kuba trying koza akimanyi kkooti abadde asobola ogimanipulate nga mu buli ngeri neekola kyayagala. Naye munnange eyo judgment tebagikoledde mwami Museveni, bagikoledde gwe munnayuganda oveeyo oyimuse eddoboozi yo to raise your voice and add something to your country. Okitegeera Museveni is not going to respect it, but at least you can do something. Thank you for watching. I'm going to leave for you the Chief Justice ng'annyonnyola ensonga zino, subscribing abaako n'omuntu omulala gw'ogabana naye n'emboozi. Nze Dr. Morgans. Thank you.
Discipline in the rank and file of the armed forces. To the extent that it exists to discipline and bring justice to its own rank and file, who are in conflict with its laws, its processes, and its procedures, the existence of the courts martial cannot be questioned. Let me conclude on this note. Courts martial are specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the courts martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system, and even unjustified in the military justice system. Having found as above, I hereby make the following declarations. Judicial power in Uganda is exercised by the courts of judicature and such subordinate courts as Parliament may by law establish. The court-martial system established under Section 197 of the UPDF Act is therefore one such subordinate court. I would declare that Section 197 of the UPDF Act, which establishes the General Court Martial, is not in breach of the Constitution. However, it is an overreach when the UPDF Act creates an offense that targets persons not otherwise subject to military law, making them criminally liable before the court-martials for offences of aiding and abetting. For creating such vulnerability, I would declare Section 117, which it is now, and Section 1171H, 1177 of the UPDA Act unconstitutional. I would set aside the decision of the Constitutional Court in this regard. I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial. I uphold the decision of the Constitutional Court to the effect that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for UPDF members, but lacks jurisdiction to try civilians for offences under the Penal Code or other enactments. I would declare that the arrest, detention, prosecution before the courts-martial of the cross-appellant respondent and civilians of equivalence under Section 1191G, read 1171G, is in breach of Articles 21, 28, and 44 of the Constitution of the Republic of Uganda. For reasons above, I would make the following orders. In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts-martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts-martial be suspended forthwith. An injunction doth issue restraining the instigation, reopening, or continuance of the respondent's trial before the General Court-Martial or other courts-martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of right before future courts-martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary courts of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant Ogwang Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal reform and amendment of the UPDF Act in order to enable the courts of judicature to exercise their mandate of judicial review over the courts martial. In this regard, an amendment of the Uganda People's Defense Forces is required to confer appellate jurisdiction to the apex courts for them to be able to lawfully entertain appeals from the courts martial. The other question Ogwang raises is a requirement to delimit what a service offense is during peacetime. I propose that a soldier who commits a civilian offense when he is off post and away without pass leave or a wall should be arraigned before the civil courts, civil as opposed to military courts. The cross appeal succeeds. The main appeal succeeds in part. I make no order as to costs.
I call upon